Commissioner Markley, can you hear us?
I can. Can you hear me?
Yes, ma'am.
Perfect.
Okay, everyone, we're about to get started. This is hopefully our last meeting as a subcommittee, we'll see, for the Land Bank Policy Review. I am Commissioner Davis. We do have other commissioners here. So Commissioner Bynum is here in person to my left, your right on screen, and then virtually joining us, thank you to Commissioners Townsend and Commissioner Markley. That gives us 4, which is really good because usually there's about 5 of us. So technically we would still be making quorum for this. So you all should have received the kind of review draft in email on Friday. If you did not, please do let Judd know, and Mr. Knapp can get you that information. But the review draft should have been sent out on Friday. If you didn't get it, no worries. Okay. Well, we will go ahead and Judd, if you can just send those out to other folks, just to the folks that are here, and then we'll go ahead and get started. Just for just some background on this, the hope is as a subcommittee, we look at this, make some tweaks, make some changes as needed. And then I will work with Commissioner McKiernan in the mayor's office to see about getting this on a standing committee agenda for the neighborhood and community development standing committee. And so with that, Judd, I'll go ahead and hand it off to you. And I'll also work on getting everybody those updated drafts.
Thank you, Commissioner. I believe Lisa sent them out on Friday. All right. All right, so in that packet was this PowerPoint that I'm going to show you today. It was the red line version of the policy that Wendy Green went through and changed and edited, and there was also a clean version, so you didn't have to see those strike-throughs too. So, but I'm gonna sum it up for you. There was a bunch of like language changes that really didn't change anything. It just made it simpler, and but I'm gonna go through the bigger changes. So for yard extension, we'll start approving again. And you see 6 is in parentheses there. That's section 6 in the policy. So we could find it. Pricing, it was stated that we thought selling these lots for appraised value was too high because most of the lots now are like $1,000. I believe Commissioner McKiernan said, let's try to sell them by size based on to make them like under $500 or around $500. So I came up with 10 cents per square foot. You see that the 0 to 500, there's 44% of the land bank lots that fall into that price range. So and then 500 to 750, there's 28%. So we're getting most of our urban lots. Our smaller lots, our 25-foot lot would be for $500. So for most of the lots that we have, it will be under like 500 or 750 actually. But so we did lower the price of them. And we did include the old yard extension rule is you can't get a yard extension if the lot is not on the same street. So the address doesn't have the same street as that your house is on. We changed that to can include undevelopable parcels that are behind the home that are basically you can't build a house on it. They're landlocked. So there's really nothing we could do with them. So gardens, I'll go to gardens. We'll start approving again, but we need to create a program for gardens. We're gonna break them up into 3 different categories. Victory gardens that are like small family gardens. These are not necessarily yard extensions because if the lot is next to them, they'll just get a yard extension and not a garden. These are more for the ones that are kind of like not by a house. would be a victory garden. A community garden, that's where a neighborhood group comes together, wants to build a garden, a bigger garden. And an urban farm, that's for like businesses to come in and grow. Options, they really liked, you really liked options in general. So it was, the only changes with that was the start date of the option agreement is the date that the Board of Trustees approves them. And then they have 45 days to sign that agreement, or it just cancels and goes back into the land bank. And then extensions was another one. It says that the land bank manager can give one extension. So that's a total of 2 years they could have. And if they need more time after that, they'll come back in front of the Board of Trustees and ask for more time. The manager's role is kind of a new one. I've been kind of doing this already, but it wasn't really written down in the policy. The biggest thing was that I was bringing forward like people that wanted the same parcel. And I was told we don't really want to see those. So now I have the authority to like take the person that applied first. The next one is the Land Bank Advisory Board. We really didn't get a decision from this this committee, but the complaint was that the MVRs that have the most land bank properties are there should be more people. So what we came up with is one additional member from the MVR with the most land bank properties in them. Holds. We got holding property for third parties are prohibited. And governing authority isn't a new thing. It was in the old policy, but I just wanted to make sure that you were aware of it. This says the policy is a guideline and you can change the rules if you want to. This is kind of the current workflow that I have. Somebody comes in and they want to land bank lot. And the first question we ask is the lot buildable? If it's yes, are you planning to build? And no, if it's the yard extensions. So now it's going to switch to our land bank lots. You could do a yard extension, you could do a garden, or you can build on it. It's kind of the summary of all of our changes. And Commissioner, that kind of sums up my presentation for our policy changes.
Thank you, Mr. Knapp. I know it's the changes are far more extensive, but those are kind of the main, kind of the meat of it. Just for some background, you know, for the public and for folks that are new to this conversation, our land bank policy up until kind of the point of this subcommittee gathering was kind of a hodgepodge puzzle of different legal opinions and ideas all being put together, very similar to our charter if you take a closer look. And so the other intention with this was to give the actual policy itself one voice that is cohesive, that is kind of all together, not contradicting, and that is easier to read. I also saw the kind of the final page count is actually shorter. And so just for the public and for wanting to simplify it, there's also a lot of good work that was done there. Wanted to open it up for questions for folks to be able to engage. And when you do speak, just make sure your microphone is on and you just say who you are and which department or area of the EUG you represent. So do we have any questions? Yes, Commissioner Townsend.
Good afternoon to everyone. I'm just sitting in today. I'm technically not a member of this committee, so it has to be, the committee has to be commended for undertaking this and all the work you've done. I did have just a few questions or comments just for discussion. So let me go back through the presentation that Mr. Knapp just completed. Kind of look and see. The yard extensions, does that property have to be, just so I'm clear, contiguous to the requester's property or not?
Yes, Commissioner, it has to be on one side of the person that's applying for that lot. The rule
Okay.
is it has to be on the same street name. So It's basically next to it.
Well, now that's different. In a block, I could see where the requester is at the end of the block and the property that the requester wants is in the middle of the block. So when I say continuous, I mean immediately touching the boundaries of the requester's property.
Yes, it has to be touching their property.
Okay, okay, so that's how it used to be. And using that example, where do we go again on the analysis? That's the word I was looking for. You had the current flow sheet and then you had the updated. So for yard extension, the requester is located contiguous, immediately contiguous to the property that he or she wants. Then do you do the analysis again that it's buildable or not buildable? Just kind of take me through that again.
With the current way, the question I asked was, is the lot buildable? Can a home be built on that lot? And if the answer is yes, it is not available for the yard extension. The applicant has to build on that property for it to be sold to them. That's the current rules, but with the policy update, it is, we are allowing yard extensions.
Regardless of whether or not they're buildable.
Yes, that is correct.
Okay, let me stop at that point and just ask for a bit of information that I don't expect you to have now at all. But I can see this having an impact on homes that may be built or not. Because in the past, we were asking that question and basically denying the requester if it was a buildable lot, but they had no intention to build, you know, a home or structures, well, particularly a home. So I would like to know, since we've had that approach, how many more new homes have been built or applications accepted with the intention to build? I know we've talked about growing our financial base, and I'm just wondering the difference between this new change and the old change and our current, where you actually could look forward to adding to the tax base and bringing in possibly new members of the community because you had new structures. So I would just like to know what that looks like number-wise since we've used that. So,
Well, Commissioner, I'm gonna give you an estimate. We have completed like 40 options. So that means people have gotten their building permit and they've had proof of funds, and I have transferred ownership from the land bank to them so they could build their house.
okay. Yeah, okay, that's where I wanted you to go back, because I know in the last several years, we've approved far more than 40 applications for people who wanted, you know, who came to us with the intention to build. So I'm hoping it's just been more than 40, but so you don't have to give me a number now, but that's what I was looking for. And then maybe if it shows only 40, that means there are a lot of people who came to us over the last several years that for one reason or another did not build. So maybe this change won't have as much a significance on that as I otherwise, you know, I'm thinking. So, thank you.
Thank you, Commissioner. We actually did have, Commissioner Towns, we actually did have extensive conversation regarding this. The information that I have in front of me, and again, Mr. Knapp, if you can find that and send that out as well, was we had 446 approved options. Out of those options, 34 were completed, 6 homes were built, and 15 of those options were canceled. Again, I want to make sure that we have all of the information. That way you can really dissect it and look at it. But the overwhelming data analysis that we had done as a subcommittee led us to the conclusion that while we would love to see folks come in and build homes on former land bank properties, they're not building at the rate in which we are awarding them. And while that's happening, we have a lot of land bank properties that are sitting under UG ownership that we do not have the budgetary means to properly maintain. And so with a lot of individuals wanting a yard extension and with us not seeing the level of success, we thought it was best to be have a different approach with this policy. And so we'll definitely get you that information, but that was kind of and other committee members, if y'all have other perspectives, please do add, but that was kind of the prevailing thought for that rationale.
Well, that's great. And that's why knowing the numbers are so important, because if over the last several years, did you say 400 people applied, that, over the same period of time, there have been about 40 builds. I'm wondering what's going on with the others. Maybe they're still in their exploratory time, but I think it's appropriate to look at that. And you're right, if it's not giving us the result that we had hoped for, then to do something else with it. Thank you very much.
Yeah, absolutely, absolutely. And I'm not in any way, shape, or form, I don't foresee this dissuading builders from coming in and looking at, the land bank and still wanting to build a home. I think the other side of that is for all of the parcels that we keep saying no to, if we can't maintain them, then are we really, making as much effort as we can? And so we'll definitely work to get you that information. And this will be one of many conversations we will have, since you and I serve on that committee with Commissioner Bynum as well. Other questions? Any others?
Commissioner, I don't know if now's a good time, but I think that, as we've gone through our months of work, we talked about, holding land bank parcels for county projects, and we have I won't say it right, we have the project for the stormwater.
Mhm.
Should we talk about that now? Are we ready to talk about that? Like, I know we have some of those parcels identified. And we had the open house a couple of weeks ago at the B. Lee Center where we showed a piece of that plan. I didn't know if now is a good time for that or not.
Yeah, I don't want to put our public works folks on the spot, but Mr. Fisher, you have any insight on that?
Well, we're attempting to get on the standing committee. But it might be good to recognize it in this flow chart somehow, if this is going to be for public consumption in some way.
I guess that's part of what I'm asking, because we do intend as a body to now look at the stormwater projects, where the land bank parcels are, and see how they integrate for good purposes. And maybe it does belong there somewhere.
Yeah, this is Troy Shaw, county engineer. I was also going to ask the question. I was kind of waiting until everybody else got done because I assumed we'd start this conversation of holding for third party. I assume that said, no, we won't hold for a third party. I assume that excludes governmental projects?
Yeah, I think, well, Judd, did you want to?
Yes, that would exclude. What we currently do now, you come to me, Public Works comes to me and says, I need this for a stormwater project. We just put it on hold.
Okay.
That hasn't changed with this policy rewrite.
Okay.
To kind of add on to that, what we will have to do, and again, this is why I'm glad we're having this conversation at the subcommittee level and then the standing committee level, because all of these conversations are going to have to evolve and include other stuff. This was really we're turning our blinders on. We are just focused on land bank, and this is what it would look like. And so other considerations have to be made. One of them will probably be the hold policy, in part because what we just approved as a body months ago with the Tremont project, which was a hold, right, for the hopes of a larger development. And so we'll probably have to also look at some language on what that would look like and what those considerations would be. But because we were talking about the hold situation, I think there's the UG purpose. And then if there is a compelling economic development value to that hold, then let's also, have some language in there. Commissioner Townsend, you had some regards to make.
Well, thank you, because that brought up the other question or topic that I wanted some more information on about holding for a third party is prohibited. And I did have in mind, like the tree map project, which is still ongoing. So will there be, first defining what the third party is, you have professionals, so to speak, in a situation like that, who are not ultimately the people we think are going to live there, although they could, versus just regular citizen who wants to buy the party. So I think it's important somewhere in this process to define what a third party is. And as you say, address directly so we don't have to guess later what happens when, a developer comes to us. How is that situation different than somebody else who comes and wants to build but isn't ready to start? And is the option, this is question 2, the option agreement process as we now know it, is this still part of the situation, part of the policy? Or have there been any changes to it?
Options overall, there wasn't many changes to it at all. It was just like the start date of the agreement, and they have 45 days to sign, and the extensions where the only changes the option agreement. Your question about the holds, it was staff's judgment that they could have just went through the option agreement and not held it at all. I mean, because the Tremont project, they came and presented it to us. And then the next month we put a hold on it. I mean, the same thing could have happened with the option agreement. They could have ran it to the option and not put a hold on that whole area.
Well, I think there was some legal advice about doing it the way it was done. So, but I guess for purposes of my question, the option still lives, right? With just these changes that are on the screen.
Yeah, yes, Commissioner, yes, it
Okay.
does. Yeah.
Thank you.
And again, we wanted to, I think, did we give more time, right? We gave more, like 15 more days, right, to sign. It was 30 days, or am I misremembering that?
There
But
wasn't a deadline.
oh, there
for
wasn't a
sign.
deadline to sign.
Yeah.
So we added a deadline to sign. The extensions was really through the land bank manager, and that really lightens our load as commissioners, where if there's compelling interest, then we leave it up to staff to say whether or not that interest is compelling, and they can, and Judd or whoever our land bank manager is, can award that additional extension. Anything else would have to come back to the board. But beyond that, it will be the same. There will be approval process, same thing for the Board of Trustees during our full commission meetings. It's all the same process.
Okay. I'm glad to see that there is a definite sign by date as part of the option agreement addition with, what you all have been looking at, that was needed. With regard to the extensions, I'm glad to hear that at some point, if someone wanted or needed an extension, it would come to the standing committee. But I would like to see some criteria so that a person would know if they came with an extension request, what the likelihood or unlikelihood is that they would be granted. It also helps us, meaning the UG, to be as fair as possible to everybody coming who's, you know, requesting an extension. That's just something to think about. So as in the legal game, we won't be, we won't be accused of being arbitrary and capricious, to say. All right, thank you.
Yeah. We can definitely add that for considerations. I'm taking some notes here and yeah, we'll definitely add that. Yeah, Mr. Fisher, you had something else.
Judd, can you go back to the flow chart? Does Judd have the authority to modify that, or does it have to go through a process? Or one of the things I'm thinking about, just like we've talked about before, I don't want to give interested parties the impression that because it's identified as land bank, that it's off the market at any point and anywhere, you know, you just need to, we just want to make sure that we have an opportunity to.
Are you referencing for the watershed project?
Yeah, for the-
Okay,
so-
yeah. Well, how about for context, can you all, because some folks might not be aware, can you all just give a brief synopsis on what that is and then how it relates to our land bank?
We'll give it a shot and then Troy can jump in. With the Public Works Department has project areas, for example, in Jersey Creek that are candidates that have land bank lots in there, and some of those are candidate projects for green infrastructure that would help augment projects and or use those lots for the green infrastructure so it can protect the community or the people that are invested in the neighborhood. There's in some cases a reason why they're land bank is because they're having water runoff problems for decades, and so we've identified some of those as candidate green infrastructure.
Anything else you wanted to add, Mr.?
Yeah, that's pretty close. I mean, that's everything. We have identified, I think we're in the Jersey Creek area, and others were with the WIFIA program over the next 5 years, going to spend around $100 million in that area with that program. And part of that program will utilize, the intent is to utilize some of the land bank lots, not in perpetuity for the UG to own, but to use them to build up infrastructure that helps protect the neighborhood and then give that back to the neighborhood so that they can use it. Maybe you just take a chunk of a lot and that's what needs to be used for the green infrastructure or whatever is necessary. And then the rest of it can go back. And that's part of what our community-based partner is going to look at when we're on board with this. So it's not in perpetuity that we're taking these properties. It's we're going to hold them because either they already have flooding problems on them and we need to help alleviate that. We don't want to give a property that has flooding problems on it to a citizen because then all we're doing is causing the same issue again. That's going to happen over and over. So really it's just a temporary hold for us to figure out what we can do with it, if it's eligible to be used for us or if it's a good property to give back to the residents.
And ideally empower the MBRs in many cases to embrace those and really make them an asset to the neighborhoods.
Yeah, gotcha.
And if I may, Commissioner, first of all, apologize for being late. Gunnar Hand, Director of Planning and Urban Design. So state law requires us to list all land bank properties. It does not require us to try to sell all land bank properties. So the way that the draft was written before you would effectively give the land bank manager the responsibility to decide what gets on the to sell list. Right now, we just put everything on the to sell list. And it doesn't have to be that way by state law. And we think this would be a better way for both transparency with the public, but also to meet all the other needs, including the UGs and Public Works and others.
Gotcha. That's really, really good information. I think one of the things that we'll have to do is make sure that both kind of policies or those initiatives are kind of working in sync with one another and just making sure that our language is consistent. That way we don't have one policy contradicting another. But I know the vision that I have is that gets solved at the standing committee level, not necessarily here. So Other questions or comments that folks wanted to make? Anything else? Okay. Well, I'll just I have some notes here and I will work with kind of the staff that has really been really excellent here. So working with planning, working with legal, working with our land bank a department to kind of go through this again and add just some language and stuff for the concerns that were expressed. For kind of the public's awareness for this subcommittee, it is my intention this is our last meeting, so we are done, right? Congratulations, team. And hand this off to our neighborhood and community development standing committee to really do that hard work. Oh, great. We have, all right, this was the slide. I wasn't sure if y'all got it. So yeah, so this is kind of what we're looking at just to kind of push all this stuff forward. There are still more conversations that we'll have on watershed project and land bank policy and everything else. But this is kind of the game plan going forward. Any questions, or does anybody have any lasting thoughts?
I'm just curious. Other recommendations, and that's a topic category, meaning, are we asking to take this to the land bank, this potential set of policy change to the land bank advisory committee?
So Gunnar Hand, Director of Planning and Urban Design, staff felt that there were a couple things that you might want to consider at the standing committee level that we certainly considered while we were trying to write our best recommendation, but felt like we maybe didn't get all the way based on comments. The first one was Land Bank Advisory Board. The note was we added one more NBR, and we don't know if that's enough. We didn't do anything new for notification because the third bullet, we don't have the bandwidth to go above and beyond. There had been comments that we'd received that said that they should do the same noticing that is required by the state for land entitlements. We think that is an overreach and untenable as it currently stands, unless the Board of Commissioners wants to invest more in the land bank program itself, i.e. more staff to do that. We literally have one person doing all of this, but we do have a couple of thoughts potentially on which way that could go if they wanted more notification in some way, shape, or form. Again, it's important to understand what we currently do in terms of neighborhood notification is above and beyond state statute. And there's no ordinance that requires us to do anything above and beyond other than this policy says we'll have this review and a staff review before it goes to standing, basically. But if we wanted to say, for instance, create some yard signs, and every time there's an option agreement up for them, we want to have that person come in and grab a yard sign just like they do for us. That puts most of that burden on the applicant, not on staff. And we could do something in the middle, but having the 200-foot notification is asking a lot.
Yeah, and just to add on to that, I have been reluctant to push for more staffing because we don't have an economic development department to begin with. And so having giving our county administrator time with a new budget that has been passed to start hiring, that's one of the reasons why I didn't kind of push as hard. For this recommendation to be sent to the Land Bank Advisory Board, if that has not been done already, I would request that staff do that as well, so that they're aware of what the changes are, and they're able to look at that. Commissioner Bynum, were there other thoughts?
I mean, I'm in favor of ways that we can include community input, most specifically the Land Bank Advisory Board. And Gunnar, just a question. The signs, when we have a change of zone or an SUP coming, those signs that are planted, are those by ordinance. Did we pass an ordinance or did we just adopt a policy?
That's required by UG ordinance.
It's by ordinance. Okay. And so you're just saying one thing could be a signage as a matter of policy, maybe not ordinance, or an option or a parcel coming.
Well, at least as I understand it, you're working on just updating the policy, not writing an ordinance to adopt this policy, which is one thing.
There's
I think that's how we've always described it
Changes.
with Wendy,
changes that she sent.
who has been the primary legal counsel that worked with us on this, but I still think that if that were to be added to this policy, we would still, I mean, obey, honor, respect that policy change and do that. It would just be the cost of, and it would effectively be the cost of the signs. The one thing that I would just quickly add on to that is very often, not always, but very often, those option agreements are put in place because they're already going to have to get some level of land entitlement that will probably require that noticing anyway. And we make very clear in our staff reports and other things that this is a land bank project as we go through that entitlement process. But
I have mixed feelings about the signage because very close to where I live, we approved something months ago and the sign still sits in the yard.
well,
you know,
there's that
so
too.
There's a little bit of almost a junk aspect to
Sure.
the signs
And
because they never take them down and you can't read them. The only thing seeing that sign tells me as I'm driving by is, oh, I might want to go look that up because I certainly cannot read it as I drive by. So I just have mixed emotions about if we wanted to try to bring that over to the land bank. It might tell me, oh, a land bank parcel. That would be all it would tell me. So.
potentially, yeah. Again, I think we ran the gamut on the feedback we got on notifications. I mean, there's as of right developments that people want notification just because there's been a building permit fold, and that's just not what we do, right? That's not state statute, that's not a requirement. And again, that's incredibly burdensome. And so that was just one idea. Yeah.
Wanted to make sure we were good on that exchange. Commissioner Townsend, you had something?
Well, I just wanted a little bit of clarification about what it is that's being debated about this notification, on what circumstances and where. What are we talking about exactly?
Our hand director of planning and urban design, the staff's recommended policy amendment that's before you is to have no change in the current policy for notification of land bank properties.
If I'll add just a little bit more context. So Commissioner Townsend, we had gotten during the kind of the community engagement sessions, we had gotten some comments from folks, some NBR folks and some neighborhood folks saying they would like a process by which land bank applicants would have to notify surrounding neighbors that they were going to file and they were, putting in an application to get a land bank parcel from the UG. We had kind of sort of discussions here and there in the past 7-8 months on this. And so that's kind of the conversation that you're hearing is what the process should be, or should there be a process for notifying neighbors that a land bank parcel is in consideration for private ownership or other ownership than the unified government.
And for those who advocated for that position, what was the benefit of that?
We had heard from some folks that had said they would like to know that similarly for a change of zone or for a permit, how there is notifications and they kind of know what's happening in their community. They would also like the land bank to follow that same protocol so that they also are aware what's happening with the land bank parcels in their neighborhood.
Well, since we have a list of what is land bank. I'm thinking that that proposal, in my opinion, would be more burdensome than beneficial. Just having or lacking really staff to go around and put those up. And then it's Commissioner Bynum saying who takes them down, whether successful or not. Whereas if you have something that's requiring a change of zone or a special use permit, that could immediately impact the rights of adjoining neighbors. So I think it's something more than just, oh, the land bank lot, somebody's going to to get that. So I see more of a burden than a benefit to that, and not necessarily on the same stature or status as something that's notice of a lease pendants is really what it is, that there's going to be an action taken on that property that's going to affect the next door neighbor's rights in some way, or even within the 200 foot radius. So one other question for clarity. With some of the things that we've discussed today, there may be additions to the language. This committee will not see that anymore before it's moved on to, say, the Eco Devo committee or the neighborhood group committee.
Yeah, my thinking on this is we have enough language and enough in a draft to send over to the standing committee level. I don't foresee any drastic edits or recommendations, but really just some edits that we may have missed as a subcommittee, or some new developments like the watershed policy that our Public Works Department has been working on. Things like that will probably need to be considered before drafting this policy. But for this subcommittee, no, we will not continue meeting in that capacity.
Just a
Well,
quick,
thank you again for the heavy lifting you all have done on this. It's taken a lot of effort, and appreciate it. Thank you.
Yeah, absolutely. I tried to get Commissioners Markley and McKiernan roped in on stuff before they exit out of here. So just trying to squeeze all of the knowledge out of them. Commissioner Bynum.
can I go circle back to it again? Because you have, I don't know the current number of registered neighborhood groups, but it's much declined from a decade ago. So let's say it's 60. Do you happen to know, Judd?
I just look at the list. I don't count them. So I don't.
So remind me again, when we do the notifications, are we or are we not utilizing that neighborhood group list? Not the NBR necessarily, but a nearby neighborhood group that's registered through Livable Neighborhoods.
Yes, we are. So I check the map after I make it, and I send emails to those neighborhood group leaders at the emails that are on that list.
That you have. Okay, so that's good. I think the concern that was shared with me was there's so much area that doesn't have a group. And then how do we, like, can we pick one way, whatever it might be? And I don't know what it would be, to make an additional notification step. Now, it's possible that since the majority of the land bank parcels are in the groundwork NRG, NBR boundaries, that we could request their assistance such that groundwork, there's a parcel here in an area that's not touched by a boundary of a neighborhood group. If you know of a resident there, could you share? I don't know. I'm just throwing more on the table, I guess.
I will say, Commissioner, given, I don't want to get too ahead. I know there are conversations regarding our
Okay.
NPRs and Eugene, all that stuff. I think that's probably where that conversation
Okay.
could live a little bit more. But I agree in that, given these are UG created entities that we are partnering with, that could be a part of the partnership that we have as we move things forward. So,
Okay,
no, I'm completely with you.
I think let's just kind of leave it on the table
Yeah.
as something to kind of keep thinking about.
Absolutely. Other comments? Yeah, okay. All right. Well, I just want to thank you all so much for taking out the time to do this work. It is not easy. It is a grind. We have been at this, believe it or not, for about a year now. Actually, for me, it's been over a year. So to come to this point and have language that we can now consider and tweak and adopt is a really cool feat. And I'm appreciative of all of you, Commissioner Markley, Commissioner Bynum, Commissioner Townsend. Thank you for joining us. And also thanks to Commissioners Ramirez and McKiernan, who also played an integral role, as well as Public Works, Planning, and Urban Design, and our Land Bank Department and Legal Department. I know Ms. Green is currently out right now, but Wendy did a lot to pull this off, so she deserves credit as well. So thank you all so much. Updates will be released in the coming weeks as far as where to go from here. But for this subcommittee, we are done. Have a good one.
Thank you.